Yes, Mr. Reed.
Just before I carry on, I've been asked to clarify that I did say that the short interruption we had, that was not the appellant. That was not a
No,
person
I
who was an
understand
individual in the case. So I just want to
understand
to make that clear. So at that stage, I'd just taken my lords to the second part of paragraph 66E in Mr Cotter's judgment, still on improper collateral purpose. I think I was just going to direct myself to one of the points that my Lord Justice Arnold had raised, which is why was the judge saying, well, it couldn't possibly hope to achieve that? Well, if one thinks about it, there are two ways in which it could conceivably go broader, and it's perhaps linked in some ways to the chilling effect point. Well, first, could it have had a chilling effect on a person who had left the PBCC but that hadn't given this undertaking? So, well, no. How could it? How could it seek to have that purpose? How could that possibly be the purpose? Now, I suppose there may conceivably be someone out there that is just has got such a low level of understanding, perhaps when they read something somewhere, they might think, well, this affects me. Well, that's a long, long way from saying that is the purpose. That is the predominant purpose, this application is being brought because it might have an impact on some such conceivable person.
I suppose you might be able to infer, if this was a sledgehammer to crack a nut, to point another analogy, it could be inferred, perhaps, that the church was just seeking to demonstrate to others that it had the muscle, the will, and the wherewithal to be oppressive towards people it didn't like.
Possibly, my lord, and it's in that context I go back to Navigator and say, well, look, the merits has its place. Look at the application as a whole. Does it have the feel of an oppressive application? Imagine these were derogatory comments, but barely crossed the line. Utterly trivial. Perhaps an unkind comment on someone's appearance or something like that. Now, I'm not saying it wouldn't be a breach, but it would, at the very least, raise a judicial eyebrow on a contempt. Is this really the stuff of a contempt application? And as that I say in response, look at the derogatory comments that were pleaded, look at those that relied on specimen charges, and obviously they were cut down, but they were all, I submit, serious in nature. My learned friend characterised them in the first instance being utterly trivial, and the judge rejected that. This is a proper stuff of contempt. There's nothing in the substance of the application that I submit can properly be characterised as oppressive or an indicia of it having an improper purpose. So I was breaking it down into the two categories, really, the logical categories. Well, is it realistically done for the purpose of having an impact on non-parties? We say no, there's nothing to suggest that that's the purpose, or indeed that it could realistically do, certainly on the facts of this case. The second aspect being, is it having a chilling effect on Mr Christie, the appellant himself? And again, one can conceive of an application where if it had been pushed either to the limits of the four corners of the undertaking or perhaps beyond it, where it might be said, look, be careful, because even if you do something that's safe, you may still be facing an action for it, and that's going to cost you time and money. You know, you're only going to get some of your costs back, and you're not going to get your time back. That might be said to be oppressive on the merits of that case, and therefore an improper purpose, and going beyond that which one legitimately can. But there's absolutely nothing in the facts of this case that go that far, and that's why we say the judge was right to conclude, actually, as he did. It just can't see how it could have achieved the purpose that was put against the respondent. So we finished at 66. The judge then picks up this point, or rather this topic, at paragraph 73 of his judgment, where he deals with abuse of process under the sort of general heading there. And at 74, he explains that the fundamental flaw with the appellant's case is that the respondent's pursuit of this contempt application simply can't achieve, let's say, what the appellant alleges is the collateral purpose. And I think my lords were taken to that by my learned friend, so I'm not going to read 74 again. And then in 75, sorry, he says the undertaking was intended to protect family members from derogatory comments. That was clearly the principal aim of obtaining the undertaking within the settlement. The bringing of contempt proceedings for the purpose of achieving the main aim of litigation cannot possibly be an improper purpose. And with respect, we agree. So that is it's self-evident that is the purpose, is to achieve enforcement of the undertaking, nothing less, nothing more. He then continues his analysis over at paragraph 84 in terms of collateral purpose. And again, I think you've been referred to that. And in 85, he says this, starting about 5 lines down. However, it misses the central issue within this application by a very wide margin. As I've explained, Mr Lance Christie can make such criticisms of the PBCC as the laws of this and other countries permit, and in holding him to the terms of his promise, the court cannot conceivably be described as an enforcer of anything other than that promise. Mr Hitchin fails to accurately portray the underlying proceedings when he states that he forms part of a long-standing campaign to intimidate critics of the PBCC to deter them from further criticism of the organisation. The provenance of the undertaking lay in litigation in which protection of the PBCC played no part in the claimant's case. Now, it's fair to say that the judge hasn't cited within his judgment any authority on improper collateral purpose, but that doesn't render it flawed, and I don't think it's put against me that renders it flawed. What the judge did was to scrutinise whether the alleged improper purpose of the contempt application was even tenable, and concluded, rightly I submit, that it wasn't. Now, my learned friend Coulson hasn't engaged with any, really, of the findings made by the judge under this heading. And again, I was listening very carefully to my learned friend's oral submissions. What is essentially done is he's conceded that it boils down to relevance, but then said, well, look, there are all these facts set out in the witness statements of Mr Hastie and Dr A.B. Mitten, who, as he rightly said, were tendered solely as witnesses of fact, and neither was tendered as an expert witness. That was made clear. Again, there was an application during the trial because they came in late and outside of the judge's timetable. And the argument about whether they should admit it did, as my learned friends, turn on relevance, essentially. Now, just to be absolutely clear on this, the position adopted by my client was this: it was not for one moment accepted that the content of these statements was true. That was made clear to the judge. What was said is that my client was not going to engage in satellite litigation about issues, factual issues, that it was contending were irrelevant. And it was expressly, and the judge noted at the time, that was understood, of course, by not cross-examining, was bound by the consequences. The judge made it very clear he would analyse them for relevance and he would assess them for weight. He would exclude that which he thought was expert evidence and therefore inadmissible. He would exclude that evidence which was clear the witness did not have an appropriate experience of it firsthand. And to the extent it was hearsay and was the proper subject of it, he would take it into account. But it wasn't accepted that it wasn't challengeable by my client. I just make that clear so there's no misunderstanding. It was dealt with by my client on bring it in and we'll argue about relevance. Now, the judge deals with the witness evidence in his judgment, and it starts at paragraph 39, where he deals with Dr. A.B. Mitten and Mr Hastie.
Just before we look at that, can I just be clear as to the chronology?
Yes.
The statements are dated the 22nd and the 23rd of July, respectively. There had already been directions, had there, about the exchange of statements,
Yes.
because the trial was the 29th. So presumably the exchange of any evidence was ordered for considerably before that.
It was. I'm afraid I don't have the precise date in my mind. Unfortunately, when the appellant was served with the application, he went to Australia and was there for several months, so it delayed his engaging with the application. The judge gave an extended date, which was, so I can't remember how long before they were served, but it was before they were served, and therefore my learned friend made an application during the course of the trial to admit those two witness statements.
Well, I've got a ruling. I've read the ruling. We've read the ruling, which is dated the first day of the trial.
That's correct. And the submissions will also be in the bundle. I'm just seeing if I've got any.
And when were I mean, obviously the statements were served sometime between the 22nd, 23rd of July and the 29th. Can you tell me when?
Thank you. I'll be able to tell my lord in a second.
Fine. Okay. Sorry, you were going on to.
Yes, sorry, my lord. I was going to just mention that the judge dealt with the evidence within the judgment. Now, I don't think my lords, unless I'm mistaken, my lords were taken that at all by my learned friend. It starts in, so it's tab 5 of the core bundle. It starts paragraph 39. It's on page 77. Now, I don't propose to take my lords through it in detail and entirely my lordship's hands, but it's from, you see, there's a section just before paragraph 39, Dr. Obi Mitten and Mr Hastie.
Well, we've read.
We've
read it, so
my lords have, and then
it's only if there's any particular point.
Well, my point really is to say this, and it carries on to page 56. As my Lord Justice Coulson pointed out, this is an appeal. It's not a rehearing. And with respect, that's right. What my learned friend did was to say, well, I've got all these evidential witnesses, evidential references. What my learned friend didn't do was to go through this, I'm going to say so respectfully, careful and correct analysis by the judge and say, well, this is where the judge got it wrong. Which means it's rather difficult for me on appeal to direct my arguments other than say, well, let's get into the weeds and look at the underlying evidence and carry out the process again. But that's not ordinarily the stuff of appeal. So I'm here to obviously assist the court, but in circumstances where my learned friend hasn't, as I see it, pointed to a specific error in the judgment, error in the reasoning, it's quite challenging to grapple with. What I might do, perhaps, if it be assistance, is to one turns back to paragraph 33 of the judgment. You will see there the 4 propositions, really, that were being relied upon to try to make good the case on collateral purpose. And these are the points A to D. They were saying that is what's trying to be proved. But the reason why ultimately the judge has concluded it's irrelevant is because
Well, D is plainly and obviously irrelevant to these undertakings and the contempt of court.
well, yes, that's it.
So wider collateral purpose or not, and A, B, and C, we've seen the references.
Yes.
And the question is, I think, as Mr. Hitchens put it, it's to do with relevance.
Yes, absolutely. And if these points don't actually, and certainly with the evidence underlying it, make good, if they're the propositions that are all leading towards the headline submission, that the predominant purpose is to stifle criticism of the church. If these propositions don't even make that good, then, and this is what the evidence goes to, then it must fail. Now, when one looks at it, actually the case being advanced didn't even go, and certainly the evidence didn't even go as far as these propositions. Because if one takes the first one, what really the appellant did was listed various proceedings that it said were by the PBCC or by an entity that had some link to or controlled by the PBCC, and said, well, there you go. That's evidence of them stifling, and it supports this this allegation of abuse. And during the hearing, the judge was very careful to probe what exactly was being put forward. Now, it was not alleged that any of those other proceedings were improper or abusive. And the judge didn't quite understand why, in that case, how it could be said that other bits of litigation could provide indicia of abuse here if they weren't abuse there. And as his lordship pointed out, I think this is in paragraph 53 of the judgment, and if one picks that up, so it's page 80, about 7 lines from the bottom. He says, many individuals or bodies, corporate or otherwise, vigorously defend their rights, and provided their actions are meritorious, it's difficult to see why this should be a legitimate ground for criticism. Now,
well, one of the most common sets of claimants in contempt proceedings are banks, and breaches of freezing orders has already been mentioned. Commercial contempt cases, I mean.
yes, but unless there's something that can be pointed to and to take it further, it doesn't actually help. And it was said, well, it's the pattern of litigation against former members. But take this case itself. Would this be held in future to be said, well, look, you were trying to stifle it more broadly? It becomes a bit of a bootstraps argument. Look at what's being done. If those other bits of litigation were directed at an undertaking that had been given and someone was held in contempt of whatever obligation they'd given, it doesn't establish a point, and it wasn't taken any further.
Mr Hitchens has placed a reliance on what Mr Justice Hamblin said in the case, as it happens, about a bank trying to commit someone, where he suggested that the court should be astute to identify oppression or abuse. I'm not quite sure I grasp the point, but I took it to be that the judge should have been more alert to the possible implications of this evidence, and or should have taken some further step or allowed some further step to be taken to make good what wasn't, on his view, good enough as it stood. What would you say to that, if that's the point? I've correctly understood it.
Well, certainly as I understand it, my lord, my learned friend's got to put his case and make out his case. We don't have the inquisitorial system here. He puts his case, and I answer it. Now, of course, if what my learned friend is saying, the judge should really scrutinise and actively express one's mind to the possibility, then I agree with you. Of course, a judge shouldn't just wave a hand and say, "Oh, this is nonsense." A judge on a contempt application should say, "Is my time, is the court's time being abused here? Is there an abuse being carried out? Let's look at the evidence and see if it's made out." But if it's not made out, then that's the end of it. It's not about. It depends what one means by raising a prima facie case. It means has it been established on the facts? And if actually it's been established on the facts and there's nothing running against it, then it's been established. And of course, there it is. The consequences follow from that. And again, yes, of course, if that's the case being asked, it should be scrutinised. If anything, I suppose what it's saying is there as contrasted with ordinary civil proceedings, more is at stake. Ordinarily, the liberty of a subject isn't at stake, and therefore the court should be alive to the fact that it has those consequences. But I don't see in my submission that it can go further than that, my lord.
Now, I can see the court might reach the point where it says, well, this has been put forward, you haven't answered it yet. I've taken the view that it is relevant and may have some weight. Tell me what you've got to say about that.
Yes.
That might be
That
a
might
way of being astute.
It might be, and again, it might be particularly so in cases where it's been raised late in the day, an unpleaded point. Again, I know it doesn't have pleadings, but there's no formal application. It's brought up, and that's actually, Mr. Reed, I know you've not answered this, but what do you say about it? I think it makes out these points. It's hypothetical here because we say it doesn't come close to making out any such case.
Thank you.
So, given my learned friend hasn't directed himself at the judgment and the judge's analysis, I don't think it's appropriate for me to just trot through all the evidence. But unless my lords have anything else on ground 3, I'm supposed to move on to sanction.
So, just looking at that, yeah, you dealt with it. You had sort of 3 subheadings, but you dealt with the underground 3, but you've dealt with it.
Really, yes, I did. So my Lord Justice Cotter is right. What I say ultimately is the judge got it right. He considered the evidence very carefully. He didn't just ignore it. There's lengthy passages that you've read in his judgment dealing with it, explaining why. There's bits of it he's going to ignore because it was expert. There's bits where he just thinks the witness is saying something that he's got no proper basis for saying it. And he analyses the allegation. He thinks it can't achieve the purpose that's put against my client and ultimately rejects it. We say he's reached the right decision for the right reasons.
Yeah.
Turning then to ground 4, sanction. The judge, rightly, as is the modern practice, gave a period for contemplation after handing down his written judgment on liability, and gave time for the appellant to put in evidence on of mitigation, and held a separate hearing on sanction. The judge undertook the conventional, and I submit entirely correct, approach to the determination of sanction for contempt. That is, he considered the 2 key aspects of culpability and harm before then adding in appropriate mitigation. And the judge was careful to remind himself about determining whether the custody threshold had been met. And again, correctly reminded himself he had to ignore the absence of other sentencing options, and he had to ignore the possibility of suspending sentence. It's absolutely the right approach. He's got to first determine was the custody threshold met. And he did that, and then took mitigation and takes mitigation into account. And I think it's common ground that the judge didn't err in that respect in terms of how he approached it. And of course, the judge held that the custody threshold had been reached for just one of those contempts, the 20th contempt, which was where he called his 2 of his sons false witnesses in the body of an email sent to over 1,000 people. And as explained in paragraph 66F of the judgment, he was accusing them of breaching the 9th commandment. Now, it's a very small point. My learned friend said it was unusual for the judge to go himself to revelations and find this out. Actually, that's just not right. As the judge says in his judgment, this is 66F, in his document, so in the appellant's document, Does Truth Matter, Mr Lance Christie sets out a number of scriptural pointers for genuine seekers of the truth, including, quote, idolaters and all liars, their part is in the lake which burns with fire and brimstone, Revelation 21 verse 8. So it was taken not from the judge's own research, but from Mr Christie's own writings, which are in this case. Now, in terms of the length,
was that reference in the email of, is it the 25th of January? The one
it's the 25th of January email, but sorry to be clear, the reference there isn't in the body of the email. Within the body of the email, the sons, amongst others,
Yes,
are called false witnesses.
I understand that.
And it was actually the document "Does Truth Matter?" was a hyperlinked. It was a hyperlink rather than a strict attachment, I should say, to an earlier email.
Yeah,
it was hyperlinked.
The 8th of January.
Yes,
yeah.
And actually, to be strictly correct, it was a second order hyperlink. So one of the hyperlinks in that 8th of January email was to a letter to the MP Michelle Donnellan.
Yeah,
and it was a hyperlink in that letter. That hyperlink was to a document called "Does Truth Matter?", which was written by Mr Christie, and it was in that, and that was the subject of the 4 earlier contempts that we would have to which second ground related.
Yeah,
that's what he was referring to. So in terms of the length of sentence, the judge said he found some assistance from the ASB guidelines. We'll look at those in a bit more detail in a moment. That's in, if we turn to his sentencing remarks, they're in tab 15 of the core bundle.
Yeah.
And
41.
And he says, although care must be taken, referring to sentencing for contempt in other areas, as types of contempt vary greatly, I've gained some assistance from the antisocial behaviour injunction sentencing guidelines, given the nature of this case. Now, my learned friend's point is a slightly nuanced one. He accepts that the judge was entitled to rely on the antisocial behaviour injunction guidelines to some extent, as a matter of principle. Indeed, as my lords pointed out, he was the one that mentioned it to the judge. The nuance was is he said, well, you can't apply it rigorously or without any variation at all. You need to adapt them. My submission is there's no warrant, there's no indication in this judgment that the judge has blindly applied them without variation. The judge was well aware of the vast range of contempts out there, and he wasn't saying, I'm therefore find that this is the closest, so I'm following it. He's just gained some assistance from it. It's entirely proper. That's not an error of law. In my submission, it's bang on. It's absolutely correct. And indeed, when one looks at it, he's well aware of the differences. In fact, if you look at paragraph 46, which is we looked at in a different context earlier, and this is in the section considering whether he should suspend or not. He says, whilst Mr Christie cannot be said to have been a conventional lawbreaker in the sense of intentional antisocial behaviour in breach, I think it should mean of an order, on an order, rather he was motivated to prove matters as he saw them, he breached an undertaking. And the judge had referred to that earlier. What he was saying was, look, in antisocial behaviour injunction cases, often one's intending to cause the harm. What he was saying here is he accepted, for the purpose of sentencing, that Mr Christie wasn't setting out to cause harm to his sons. He may have caused them harm, but that wasn't his intention. His intention was other campaigning purposes, and therefore he was drawing a distinction on the facts between this and the antisocial behaviour type contempt. So he was well aware of the distinctions, and I submit took that into account when coming up with the sentence. And of course, that was 14 days custody, suspended for 12 months. And I say, in that respect, the judge made no errors of law. And indeed, it might reasonably thought, in my submission, that that's at the lenient end of the spectrum. I make quite clear there's no cross appeal. I'm not saying it was unduly lenient before this court, but my submission is, or might reasonably be said, that the appellant has got off lightly here. in any event, my submission, it's well within the range of sentences reasonably open to a judge for this particular contempt. So, looking at now, what does my learned friend say? Well, he takes 3 points. Firstly, he says the judge applied the ASB guidelines without adjustment and was wrong to do so. Secondly, he said the judge found that the 20th contempt was a medium harm offence and was wrong to do so. And thirdly, he says the sentence is manifestly excessive. I'm just going to go through those points in a little more detail. I've already explained and shown, my lords, the sentencing remarks. The judge, I should also take my lord to these parts of the judgment. Sorry, apologies, I went slightly out of sequence. The judge was well aware, as I think it was my Lord Justice Arnold said earlier, that almost every case for contempt is different. There's a very, very wide range, and everyone is fact specific, and that's why one has to be very, very careful looking for comparators in other authorities. At paragraph 9 of the sentencing remarks, the judge said, this is page 195, there are a substantial number of authorities on sentencing for contempt, but many of the observations made were highly fact specific. With respect, I say that's right, so the judge is well aware of the need to be acutely aware of the facts in this particular case. Then at paragraph 32, over on page 201, the judge said, in many cases involving other forms of contempt, such as with antisocial behaviour, there's a direct hostility or animus and a desire to inflict some harm or damage on the person who has the protection of the order. Although Mr Christie's family clearly should have had the protection from the undertaking, it was his misguided belief was that by criticising the church he could somehow reconcile with the very family members he was making derogatory comments about. Any suggestion he did what he did with the aim directly of causing harm is, in my view, implausible. So again, he's said that for the purposes of sentencing, he accepts what the appellant was saying at that stage. I didn't mean to cause some harm. He's taken it into account, and he's well aware of that distinction from the ASB guidelines. So he's taken it into account in my submission. And I've already taken you to paragraph 41. In my submission, these points all point away from the central submission of my learned friend that he's applied the ASB guidelines without adaptation. He's clearly aware of that. And when one then looks at how he applied them, in effect, that comes in at paragraph 42 of the judgment, of the sentencing remarks, where he says, Mr Justice Cotter says, the derogatory comment that comprised contempt 20 was clear. It was in the body of the email. It followed a shot across the bows about the need for compliance with the order, but the harm should be considered as low. Using the ASB sentencing guidelines, it would be at B2 to 3 before mitigations taken into account. Now, just pausing there, so the judge has said the harm should be considered as low. Of course, my learned friend has said, well, he found it as medium. It's all relative, and I made a point about this in my skeleton. When one says low, medium, high, it's by reference to what? Clearly, what the judge is saying, well, if it's by reference to the ASB sentencing guidelines, it's actually in the low to medium category. And if one looks at those, they're in the supplemental bundle. Just to remind my lords, I think we went to them briefly, tab 13. And if you go to page 110, please, down at the bottom, it explains harm. And of course, Mr Justice Cotter was at the time was His Honour Judge Cotter, who chaired the working party that led to the report to which this was an annex. It says harm. The level of harm is determined by weighing up all the factors of the case to determine the harm that was caused or was at risk of being caused by the breaches. In assessing any risk posed by the breaches, consideration should be given to facts or activity which led to the order being made. And then at the top end, for this type of contempt, you've got category 1, breaches causing very serious harm or distress. Category 3 at the bottom end, breaches causing little or no harm or distress. And then Category 2, cases falling between categories 1 and 3. And again, the judge isn't saying this falls squarely between in Category 2, i.e. it's not between 2 and 3, it's somewhere between 2 and 3. So it's a fairly nuanced approach, if I may respectfully say so, from the judge. Why? Well, he's using it as some guidance, but it's just that. He's saying, well, look, this gives me some sort of broad feel of what I might impose for this sort of contempt on the facts of this case. He's trying to give his reasoning. And then over on the opposite of page 111, I think you saw that the range, if it's straight in Category 3, really it's from 0 up to 1 month. If it's Category 2, it's 0 up to 3 months, the starting point of 1 month. So, one's got a fairly broad range there between 0 and 3 months. I think it's probably not something that's susceptible to a mathematical exercise, of course. My Lord's well aware of the sentencing principles, but it gives one a sort of range. And in my submission, where the judge has ended up is entirely appropriate. It might be, say, some judges might have ordered a higher sentence, but it's well within the range that was open to him, and certainly my submission can't bear to be said manifestly excessive, and certainly there's no proper basis for saying on this that he's applied these guidelines without adjustment at all. They've just assisted in the process.
Yeah.
So I've slightly, whilst of course the first point is on the ASB guidelines, there is a linkage through to harm, and as I've gone on to that, the second point, they to some extent interact with each other, of course. And the judge dealt with harm in his sentencing remarks. He started at paragraph 19, and then at paragraph 20 on page 198, he says this: in my view, it's a relevant fact that Mr Hitchin's submission is made against the background of evidence produced an argument so far that this application was probably made at the request of the church by which he was directed. I considered aspects of this in my judgment, and it's not for me to speculate further on the motivation. Rather, my focus must be on the fact that the family are entitled to the protection of the undertaking and not to have derogatory comments made about them. As I've set out in the judgment, taken objectively, being called a liar or perjurer is unpleasant and likely to cause upset or annoyance to any reasonable person. The undertaking was principally to provide protection against such harm. Of course, where he's talking about, as I've set out in the judgment, that was linking back, I would say, to paragraph 66F, the one we looked at a few moments ago, and I'm not going to go back to that. And then over at paragraph 25 of the sentencing remarks, the judge said this: as I've indicated, I view the contempts in the second email, that's the 25th of January one, to be of a different and more serious nature, i.e. different and more serious nature compared to the 8th of January that he'd mentioned just above and concluded the harm there was low. He said the 25th of January email was sent to over 1,000 people and was headed open letter to all the brethren, and it directly referred to Jed and Josh Christie as false witnesses. I think it's entirely proper to proceed on the basis that such an email would cause distress, annoyance, upset, distress and annoyance to any person, and thus cause harm to any person in those circumstances. Now, in my submission, that was a finding entirely open to the judge without having direct evidence from Jed Christie or Josh Christie. And my learned friend took you to the authority of Chow, and if I may just refer very briefly back to that, it's in the authorities bundle at tab 17. it is a criminal case, and the key question there was whether the sentencing judge needed expert evidence in order to make a finding of severe psychological harm, and the court considered obviously that question and addressed the sentencing approach, and then at paragraph 22 said this: save where there is an obvious inference to be drawn from the nature and circumstances of the offence, a judge should not make assumptions as to the effect of the offence on the victim. The judge must act on evidence. In my submission, what the judge was doing was essentially the first bit of that. There was an obvious inference to be drawn from the nature and circumstances of the offence. The judge feels, given the very serious nature of these words used in this context, that it's obvious that that would cause harm to any person. And that's a conclusion as a matter of law he's entitled to draw. It doesn't have to have a direct witness statement from a victim to be able to reach that conclusion. And Chow doesn't stop him from doing that. I should also point out, as is mentioned in paragraph 8, where of Chow, it quotes from section 143(1) of the Criminal Justice Act, and said in considering the various factors you have to consider harm caused, this is the fourth line, harm which the offence caused, was intended to cause, or might foreseeably have caused. Now that the Criminal Justice Act 2003 that bit was actually repealed, and it's been replaced by section 63 of the Sentencing Act 2000, but the wording in that respect is identical. It's worth noting the final bit of it, might foreseeably have caused. Actually, it falls, even if the judge wasn't saying it's actually caused that harm, it's perfectly entitled to say it might foreseeably have caused that harm.
Mm-hmm.
I should say I've not put in a respondent's notice on this point, so I don't press it too far. I simply make the court aware if that's what's properly entitled to fall within it. So I say the judge hasn't erred on the facts here. He was perfectly entitled to say that calling your son was a liar, particularly in a religious context, is bound to have caused a degree of harm, and he's not erred in finding the level that he reached. So overall then, was this a sentence that was manifestly excessive in all the circumstances? In my submission, no. The judge has approached this by taking into account culpability, as he should, and it's accepted when he found a medium level of offence. This, my learned friend accepts he was entitled to do that. He's properly addressed his mind to harm and was entitled to make those findings. He's properly reminded himself that, in a sense, every contempt is unique, but has tried to find some guidance and seek to use that to an appropriate extent. He's not used this as legislation, it's completely binding on him. He's gained some utility from it, just as one would expect of a judge. He's taken all the mitigation into account that reasonably could have taken, and as the judge says in paragraph 47 of his judgment, relying on Isbelin and Turk, he's entitled to go down the road of mercy in appropriate circumstances, and has done so. And it's in all those circumstances that the judge has concluded that that 20th of contempt did meet the custody threshold, and that the appropriate sentence was 14 days, and that it's appropriate to suspend. Looping back in, of course, and I know this is ground one, I don't mean to spoil my own friend Lord Justice Coulson's notes, but of course now ground one does loop into this point about manifestly excessive, so actually it is Article 10 compliant. If one considers what's been done here, namely one has breached your own undertaking to the court, it's been done perhaps in the context of campaigning, but actually it's been explained many, many times that campaigning could have been done without calling your son a liar. That is a narrow interference, and therefore it's easier for a custodial sanction to be compliant with Article 10. I should say in relation to this, I think my Lord Justice Arnold asked me a question just before the short adjournment by reference to a 2-year sentence and asked whether Article 10 was engaged, and I obviously answered it in terms of engagement. I perhaps should have gone slightly further in terms of it's not just engagement that one has to consider, it's or indeed interference, because they're in a sense one and the same. It's whether there's a violation, which is obviously much more. So once it might
I
have
understood you to accept that a proportionality assessment was required, and that would be an obvious example where there might be problems.
My Lord, yes. And again, to put some colour on it, if indeed it's necessary, all the facts and circumstances have to be considered. So imagine a scenario whereby decades ago someone had given an undertaking not to make any reference to another person, a bit like in Mionis. They were a private citizen at the time. And then years later, decades later perhaps, the person that had the benefit of that undertaking became the Prime Minister. And then the person who'd given the undertaking comes into information of very acute wrongdoing by that person now holding high office. And they publish something in breach of their undertaking given years before. That would be a contempt. But imagine if it was something of, I don't know, spying for a foreign country. Somehow this was a Russian agent that had made it up to be Prime Minister of our country. Undoubtedly, the court would very much take that into account when it comes to sanction, if indeed anyone was perhaps foolish enough to bring contempt proceedings in those circumstances. That's one where one might rightly say, bluntly, I think I can understand why they breached their undertaking. You shouldn't have done it, really, but the sanction should be low, and indeed it might not be right in those circumstances to impose a custodial sentence. Here we see there's no such concern here. Imposing a 14-day suspended sentence simply doesn't violate Mr Christie's Article 10 rights, given the nature of what he's done. Sorry, I've been reminded, thank you. My Lord Justice Coulson asked about the dates of service.
Yeah.
I've been given the witness statement of Dr. A.B. Mitten was served on the 22nd of July, and that of Mr. Damon Hasty was served on the 23rd of July.
Right, so served the same day they were, it appears they were sworn. Yeah. Thank you.
Well, unless I can assist further.
No, thank you very much. Thank you very much. Yes, Mr Hitchens, anything in reply?
A few brief points, my lord. First, in respect of the astute point, the exchange between my lord, Lord Justice Warby and Friend, as to what our case is in improper collateral purpose. My lord's right. I do rely on the repeated judicial statements that the court ought to be astute, intersecting when proceedings are brought for an improper collateral purpose. The authority from the then Mr Justice Hamblin, my lord refers to page 237, the authority's bundle.
Yes, that must be a Ukrainian bank, I think. I can't pronounce it.
It is. I'm avoiding pronouncing the name of the case, my lord, because I'll struggle to do so, but it's that's right. And then it's page 516. You have the extract from Navigator, which is Lady Justice Carr's judgment, in which her ladyship again said the cause ought to be astute. And just to be absolutely clear, what I say went wrong in this case is encapsulated at page 80 of the core bundle, paragraph 53, when his lordship says it's difficult to see what arguable relevance there is.
Sorry, page
8080, my lord.
Thank you.
The core bundle, paragraph 53. It's impossible to see or it's very difficult to see what possible relevance there is of the evidence of Mr Hasty and Dr Rabbi Mitten. The error, I say, is that his lordship failed to recognise that prima facie that evidence did call into question whether or not these proceedings were brought for an improper collateral purpose, and that at the very least the court ought to take steps to satisfy itself, to be astute, to check that it was brought for a collateral purpose. Now, my Lord Justice Warby gave examples of how that might have been done, asking for some further evidence from the appellant, from the respondent, giving the respondent an opportunity to respond to what is said or set out in evidence why there wasn't any improper collateral purpose.
They couldn't do that because you only provided these a few days before the hearing.
The context of this, my lord, is that my instructor solicitor and I were instructed very, very late.
I'm sure that's right.
And I absolutely
But you needed the court's indulgence for this to go in the first place.
and we would have required further indulgence. I accept that for the court to take the steps which I say they ought to have taken.
So you can't say that, well, they should have put in their own evidence because there simply wasn't time.
Well, his lordship could have called for a response, or
Sorry, say again?
an opportunity for further evidence. There was also an issue that was
You needed the indulgence of the court. You were granted it.
yes.
Like you said, you were lucky.
In response to Lord Justice, the question that was posed, this is where I say it went wrong. Firstly, it was a failure to identify it as relevant, and to therefore apply his lordship's mind to the correct, what I say is the correct question. And then secondly, no steps were taken to establish whether in fact it was brought for a proper purpose, whether that be through asking for a response from respondents, further evidence, whatever approach might have been taken, it wasn't. And I say that was where the error arose. Just on improper collateral purpose, my learned friend addressed your lordships on the nature of the application and the allegations which were brought, and it was said that because the allegations which were brought were meritorious and were tightly confined to the proper boundaries of the undertaking, your lordships can find comfort that the application was brought for a proper purpose. My lord, of course, the history of this application is that there were 59 contempts which were initially brought. Following an order of Mr Justice Cotter, the respondent then reduced those to 16. Of the 16 contempts allegations which were brought, and I'll give your lordships the reference, I won't, unless it assists you, ask you to turn them up. But of the contempts that were brought, 3 were not found, or his lordship did not find it necessary even to reach a conclusion on them because they didn't add anything to the application. So you have page 96, the core bundle, you have paragraph 101, where his lordship found that contempt number 12 was not proved. That was the suggestion by my client that his ex-wife had made contentions that were simply not credible. His lordship found that did not amount to contempt. Then at page 97 of the core bundle,
Sorry, what's the headline point?
the headline point
There were 16 tried and 13 found.
and then even the ones that were ultimately found, none of them were found not to be sufficiently important or significant to impose a penalty. And I say this,
They were found to be contempts of court.
they were, my lord. But
We're dealing with merits and the point about whether the court can take comfort from the fact. So what's your response? I'm not following.
What I understood my learned friend to be saying is that this was a tightly contained, meritorious application that did not stray in any way beyond the bounds of the undertaking. And what I'm saying is, in actual fact, there were 59 contempts alleged, which is a large number of contempts to allege. Of those, only 16 were proceeded with, 3 were not proved at all, and then when you got to the stage of sentencing, a number of them were deemed not to justify any penalty whatsoever. So I say that is not
13 out of 16 contempts were proved.
13 out of the 59 initially.
No, 13 out of 16 that were tried.
Yes, were proven,
Yeah.
and 12 of those were deemed not to justify any penalty.
Again, a generous approach by the court. But how does this help on the merits?
Well, my lord, the point is, what I understood my learned friend to be submitting is that the nature and the scope of the application fortifies the judge's conclusion that this was not brought for an improper collateral purpose. What I say is when a litigant brings a large number of contempt allegations, many of which I say respectfully were not sufficiently serious for the court to make findings on, or for the appellant or the respondent to feel the need to proceed to trial on, that is not indicative of a moderate, tightly confined approach, which is consistent with my learned friend's submission that this plainly was not an application pursued for an improper collateral purpose. I say when you actually take a wider view of the application and litigation history, that submission is not made out. And I say, my lord, that's particularly true of the 8th of January email, which was the focus of ground 2, which I'm not pursuing. But the point that I made there, this was an email that contained a number of hyperlinks. Midway through a lengthy, dense block of text, there's a link to a letter to an MP. At the end of that letter to an MP, the last hyperlink of many, in the last paragraph, there's a link to a very lengthy document, buried in amongst which, 15 pages in, the first comment alleged to amount to contempt is found. So while I accept that his lordship, and I don't seek to depart from his lordship's finding that these were not trivial contempt taken altogether, but some of these were, my lord, and that's reflected in his lordship not making findings in respect of them, and then subsequently not imposing a penalty. My lord, the issue of revelations, can I just explain this point? So, his lordship referred to revelations at page 87, subparagraph F, and he said at page 44 of the Does Truth Matter document, which I just referred to.
Sorry, 87 paragraph F.
Yes.
Yes.
So
This is dealing with your utterly trivial submission.
My lord, it is.
And oh yeah, down the bottom.
Yes.
Yeah.
And the point is, yes, I think there may have been reference to revelations somewhere in the Does Truth Matter document, but you have the relevant page to the Does Truth Matter document at tab 11 of the supplemental bundle. It's only pages 1 to 21 that you have, because those are the ones that are actually relevant to the matter in issue. So it's 23 pages beyond the relevant part of the document where my client quotes a bit of scripture. And to extrapolate from a verse of the Bible buried in his very, very voluminous writings, and to extrapolate from that the likely harm of a contempt, I say, is a stretch, respectfully.
Because it's difficult to find.
Well, not because it's difficult. Well,
you said buried in there now twice in relation to two different elements of this.
Well, for two reasons. Firstly, it's not proximate. It wasn't close to the actual comments complained of. But secondly, I just say it's inherently dangerous for a secular court to read an extract from the Bible and then form a conclusion on how serious a contempt is based on its interpretation of a quoted verse of the Bible. I just say it's an unusual approach, by the way, to the issue of harm in contempt proceedings.
But they are contempt proceedings that arise out of different views of the Christian faith.
Yes, and I
so
say,
the Christian faith is the context and background of all of this. Mr. Christie wouldn't be a campaigner if it weren't for the different views as to how you should go about following the teachings of Christ. So we can't divorce the biblical context, albeit that I think this is the first time I've seen a case in which Revelations has been regarded as a relevant factor.
Or the Ninth Commandment. And
But what he's doing here, surely, is trying to evaluate what Mr. Christie was saying, not forming his own view about its gravity independently. He's using Mr. Christie's own writings to interpret what he thinks
yes,
is the gravity of his allegation. And he's saying, well, he thinks, because he believes in these propositions, that the people he's accused of lying should be treated in the way specified in Revelations.
Well, and indeed the targets.
yes.
Is that an illegitimate
Well, I say an assessment of harm.
process?
Assessment of harm should be objective, my lord. It can't be the case that someone, because they're religious, is entitled to higher protection from the court, or indeed because someone's religious, and it's likely that they would consider being a liar more serious. That their actions are considered to be more serious.
Well, I'm taking it that he was applying the approach that we've been reminded of by Mr. Reed in criminal sentencing, that harm is not only the harm that's actually caused, it's the cause, the harm that's intended and the harm that's foreseeably likely. All of this being described as trivial by the individual who characterises liars as people who should end up in the lake, described in Revelations. Is that wrong?
Well, my lord, I say there should be an objective assessment of harm. I say that the court delving into the likely religious views or the likely religious perspective of the litigants in this case.
They're just quoting him.
Well, my lord, he's quoting something he said quite separate from the actual contempt that complained of, some 20 pages away, where my client's setting out his general religious convictions. If the point might have had force if my client said, it was alleged, for example, that my client said, Jed Christie is a liar and therefore he's going to burn in hell.
But I just don't understand this submission. Surely, if you're considering the harm to the person who's being protected by the undertaking, and the allegation is the subject matter of the contempt allegation is you're a liar and a perjurer, surely it's relevant to inquire whether the target is someone who says truth is overrated, or whether the target is someone who says, I adhere to the Bible and I adhere to the Ninth Commandment.
But
How can that not be relevant?
Well, there's no evidence.
Excuse me, there is relevant. We know the targets are members of the Plymouth Brethren.
And we know what the Ninth Commandment says. We know what Revelations say. But what I'm saying is there's no direct evidence in this case.
Well, you've made that submission, and we'll have to evaluate that.
Yes. It's a point that I sense may not find simple. But the simple point I was trying to make is that an objective assessment of harm, and that elevating harm as a result of the court's interpretation of scriptural writings by my client is a dangerous or an undesirable path to embark upon. But my lord, can I just turn my back for 1 moment? So I think my lords, unless there's anything else I can assist with, I've no further submissions.
No, thank you very much, Mr. Hitchens. Right, thank you both very much. Thank you to all those who have assisted. We will reserve our judgments. You will receive a copy of them in draft. That's an opportunity to comment on the spelling, typos and grammar. It's not an opportunity to re-argue the case. The draft judgments are confidential. If it hasn't already been done, a list needs to be provided of those who are to receive the confidential judgment, and that's restricted to the lawyers, and it is best to have one representative of either side, one lay representative of either side, from whom you can take instructions. That's a very limited purpose, and it is important to say in this case that the confidential drafts are confidential. They're protected by privilege, and any reference to their drafts is a contempt of court. See the Counsel General for Wales case. Once you've digested the drafts, we hope you'll be able to agree an order between you to reflect the result. The judgment will itself then be handed down electronically. There won't be another hearing. If you can't agree every element of the order, the best thing to do is to provide a copy of the order with two different colours for the two bits that you disagree about, and you can provide very short written submissions on the points on which you disagree, and we'll decide those on paper without a further hearing. And as I say, the judgment itself will be handed down without a further hearing. Thank you very much.
Court right, favourable.